Now, as you can see, we really want you to press no to the specific gift clause. And we're going to spend a bit of time why that's the case. So there are two types of gifts in a will. Specific gifts, such as my special car to my son. So in this case, the client gifted a $280,000 Jaguar to his son and an equivalent of $280,000 in cash to his daughter. That's a specific gift. Now, what happened here is the father said he would never sell it, but Dad went into retirement care, had dementia, and the Jaguar was sold. What happened? After Dad dies, the money goes to the girl, but the gift to the boy fails. I went to the lady's home and explained that the was fair to have both amounts going to one to the boy and one to her. And at the kitchen table, her husband reached over to me and held me by the shoulder and said, "Dr. Davies, we would love to hand some money back to my wife's brother, but we've got private school fees and we can't do it." So it is a real nightmare. So let's have a look. Now let's leave some cash. So we're going to leave 250,000. If you want to do that, then just type in yes, the person's name, 250,000. But please don't do it. Please don't do this. If you have only got $250,000 left, so let's say you're worth $5 million, well, $250,000 to someone, a friend or whatever, is not much out of 5 bricks after 5 million. But what happens if that assets start to deplete down to, say, when you die, you only have $250,000? Then this person, your old friend, your old mate, he gets a $250,000, and the residuary beneficiaries, the beneficiaries here, get nothing. So what we want you to do is to answer no to this question, no, and then on the next question, its beneficiaries, divide everything up by way of percentage, so 50% in this instance, and let those two beneficiaries fight it out. Still not convinced? Now, if you are convinced, just press no. You don't have to watch this video. Let's now do jewellery and tools in the shed. Now, in this great state of Victoria, the word personal belongings has two different meanings. Therefore, you don't know what the word personal belongings are. So you're using strange words which the court don't know. What's that? You're going to build your will for New South Wales. And what does New South Wales think about personal belongings? Well, the courts of New South Wales haven't considered it. Don't cause trouble. Just say no to this question. But Professor Davis, I've got my Ludrow, I've got this, I've got that. Just let the kids work it out. Let the family work it out. Gifting shares in a company. Again, you own shares in a company. You can gift them if it's important that someone actually receives the shares. If you don't do that, then they're just divided equally or divided up between the beneficiaries by way of percentage that you've put in there. Now, I'm going to spend a bit of time on family trusts. Family trusts are not part of the assets in your will. You cannot leave assets in a family trust, and you cannot leave the family trust itself in your will. It can't be done. There's court cases that say it. However, you can leave the company that may be trustee of a family trust, but it doesn't have that much value because it's the appointor that can sack and hire the trustee. So you really need, and let's not discuss it now, but another time after you've signed the wills and powers of attorneys, come back and we'll have a good discussion about succession planning on your family trust. And that's done by way of a deed of variation, which has nothing to do with today's discussion on wills. Pets. Now, pets are a gift. Pets are an asset. And there is some help there. If you do want to give away your animal, then you can do so. Make sure you leave a good lick of money behind for them. So yes, yes, that's my cat Jelly Bean and my boxer dog. My first dog was called Prince, beautiful little boxer cross, and our current cat is called Jelly Bean. My son's cat's called Jelly Bean, and we'll give that to Lucy. Small as. So Lucy, better has she got a middle name? Joanne? Okay, we'll make sure her middle name's in. So Lucy will now get that, but the gift will fail if I don't own if I have no pets the date of my death. I don't really want you to do it. Surely your residuary beneficiaries are not going to put down your dog or your cat, but that's if you want to do it. So please don't. Please press no. Now, with guardians, so if you've got children under age, then there's a maintenance trust already in your will. It's automatic. It's in all wills. So therefore, that the executors can peel off as much money as the people looking after your children need, or for private school fees or whatever. So you don't need to give the guardians any money. They've already got that. They've already got that right. Charities, if you are leaving money to a charity, again, we prefer that you don't do a gift to a charity, a specific gift. You'd rather just leave 2% or 1% or 20% to the charity in the residuary beneficiary clause. But if you are, this is how to do it. So here's example: Mission Australia and ABN. So let's give them some money. So we're going to press yes. Mission Australia. I'm going to search their ABN, and it is an ABN. And I'm going to give them, well, that's the ABN there. There we go. ABN there. And I'm going to give them $200,000. The sum of $200,000. That's how you do it. Please don't. Just leave the percentage. It's better. Now, if you are worth 5 million, I'm not that fussed about it. But if you're only worth $1 million and you've given away a fifth of your assets by Pacific gifts are paid out first. Now, what happens if a beneficiary dies before you? Then there's a bloodline gifting clause. It's common in all Australian wills. It's not peculiar to legal consolidated. So here we're going to leave Robert the Bruce. We're going to leave him $200,000, but we don't. Robert's a friend. We don't know his children. So under the terms of the will, if Robert dies, what he would have got, that $200,000 would go to his children. But in this case, we're going to override it. But this gift fails if he dies before me. So now I now have it that the gift will fail. So there's no bloodline gifting clause in that. But I'm going to take up advice of Professor Davies. I'm pressing no, and now we're going to start talking about the residuary beneficiaries next.